and that no man shall be disinherited, nor put out of his franchises or freehold, unless he be duly brought to answer, and be forejudged by course of law. And if anything be done to the contrary, it shall be redressed, and holden for none. So great moreover is the regard of the law for private property, that it will not authorize the least violation of it, no, not even for the general good of the whole community. If a new road, for instance, were to be made through the grounds of a private person, it might perhaps be extensively beneficial to the public, but the law permits no man or set of men to do this without consent of the owner of the land. In vain may it be urged that the good of the individual ought to yield to that of the community, for it would be dangerous to allow any private man, or even any public tribunal, to be the judge of this common good, and to decide whether it be expedient or no. Besides, the public good is in nothing more essentially interested than in the protection of every individual's private rights, as modelled by the municipal law. In this and similar cases the legislator alone can, and indeed frequently does, interpose, and compel the individual to acquiesce. But how does it interpose and compel? Not by absolutely stripping the subject of his property in an arbitrary manner, but by giving him a full indemnification and equivalent for the injury thereby sustained. The public is now considered as an individual, treating with an individual for an exchange. All that the legislator does is to oblige the owner to alienate his possessions for a reasonable price, and even this is an exertion of power which the legislator indulges with caution, and which nothing but the legislator can perform. Nor is this the only instance in which the law of the land has postponed even public necessity to the sacred and inviolable rights of private property. For no subject of England can be constrained to pay any aids or taxes, even for the defence of the realm or the support of government, but such as are imposed by his own consent, or that of his representatives in Parliament. By the statute 25 Edward I, chapter 5 and 6, it is provided that the king shall not take any aids or tasks but by the common assent of the realm. And what that common assent is more fully explained by 34 Edward I, statute 4, chapter 1, which enacts that no talents or aid shall be taken without assent of the archbishops, bishops, earls, barons, knights, burgesses, and other freemen of the land. Footnote: see the historical introduction to the Great Charter, etc., sub anno 1297, wherein it is shewn that this statute, the Taliagio non concedendo, supposed to have been made in 34 Edward I, is in reality nothing more than a sort of translation into Latin of the Confirmatio Cartarum 25 Edward I, which was originally published in the Norman language. End footnote. And again by 14 Edward III, Statute 2, Chapter 1, the prelates, earls, barons and commons, citizens, burgesses, and merchants shall not be charged to make any aid, if it be not by the common assent of the great men and commons in Parliament. And as this fundamental law had been shamefully evaded under many succeeding princes, and benevolences extorted without a real and voluntary consent, it was made an article in the Petition of Right 3 Charles I, that no man shall be compelled to yield any gift, loan, or benevolence, tax or such like charge, without common consent by Act of Parliament. And, lastly, by the Statute 1 William and Mary Statute 2 Chapter 2, it is declared that levying money for or to the use of the Crown, by pretence of prerogative, without grant of Parliament, or for longer time or in other manner than the same is or shall be granted, is illegal. In the 3 preceding articles we have taken a short view of the principal absolute rights which appertain to every Englishman. But in vain would these rights be declared, ascertained and protected by the dead letter of the laws, if the Constitution had provided no other method to secure their actual enjoyment. It has therefore established certain other auxiliary subordinate rights of the subject, which serve principally as barriers to protect and maintain inviolate the 3 great and primary rights of personal security, personal liberty, and private property. These are 1. The Constitution, powers and privileges of Parliament, of which I shall treat at large in the ensuing chapter. 2. The limitation of the King's prerogative, by bounds so certain and notorious that it is impossible he should exceed them without the consent of the people. Of this also I shall treat in its proper place. The former of these keeps the legislative power in due health and vigour, so as to make it improbable that laws should be enacted destructive of general liberty. The latter is a guard upon the executive power, by restraining it from acting either beyond or in contradiction to the laws that are framed and established by the other. 3. A third subordinate right of every Englishman is that of applying to the courts of justice for redress of injuries. Since the law is in England the supreme arbiter of every man's life, liberty, and property, courts of justice must at all times be open to the subject, and the law be duly administered therein. The emphatical words of Magna Carta, spoken in the person of the King, who in judgment of the law, says Sir Edward Coke, is ever present and repeating them in all his courts, are these: Nulli vendemus, nulli negabimus, aut differemus rectum vel justitiam. And therefore every subject, continues the same learned author, quote, for injury done to him in bonus, in terris, vel persona, by any other subject, be he ecclesiastical or temporal, without any exception, may take his remedy by the course of the law, and have justice and right for the injury done to him, freely without sale, fully without any denial, and speedily without delay. End quote. It were endless to enumerate all the affirmative acts of Parliament wherein justice is directed to be done according to the law of the land, and what that law is every subject knows, or may know if he pleases, for it depends not upon the arbitrary will of any judge, but is permanent, fixed, and unchangeable, unless by authority of Parliament. I shall, however, just mention a few negative statutes, whereby abuses, perversions, or delays of justice, especially by the prerogative, are restrained. It is ordained by Magna Carta that no freeman shall be outlawed, that is, put out of the protection and benefit of the laws, but according to the law of the land. By 2 Edward III, chapter 8, and 11 Richard II, chapter 10, it is enacted that no commands or letters shall be sent under the Great Seal or the Little Seal, the Signet or Privy Seal, in disturbance of the law, or to disturb or delay common right. And though such commandments should come, the judges shall not cease to do right. And by 1 William and Mary Statute 2, chapter 2, it is declared that the pretended power of suspending or dispensing with laws, or the execution of laws, by regal authority without consent of Parliament, is illegal. Not only the substantial part or judicial decisions of the law, but also the formal part or method of proceeding cannot be altered but by Parliament. For if once those outworks were demolished, there would be no inlet to all manner of innovation in the body of the law itself. The King, it is true, may erect new courts of justice, but then they must proceed according to the old established forms of the common law, for which reason it is declared in the Statute 16 Charles I, chapter 10, upon the dissolution of the Court of Star Chamber, that neither His Majesty nor his Privy Council have any jurisdiction, power, or authority by English bill, petition, articles, libel, which were the course of proceeding in the Star Chamber borrowed from the civil law, or by any other arbitrary way whatsoever, to examine, or draw into question, determine or dispose of the lands or goods of any subject of this kingdom, but that the same ought to be tried and determined in the ordinary courts of justice, and by course of law. 4. If there should happen any uncommon injury or infringement of the rights before mentioned, which the ordinary course of law is too defective to reach, there still remains a fourth subordinate right appertaining to every individual, namely, the right of petitioning the King or either House of Parliament for the redress of grievances. In Russia we are told that the Tsar Peter established a law that no subject might petition the throne till he had first petitioned 2 different ministers of state. In case he obtained justice from neither, he might then present a 3rd petition to the prince, but upon pain of death if found to be in the wrong. The consequence of which was that no one dared to offer such 3rd petition, and grievances seldom falling under the notice of the sovereign, he had little opportunity to redress them.